In this episode, I would like to discuss one important Latin maxim of the law of torts, that is Injuria sine damnum. That means injury without any damage. We know that if any person suffers some damage because of the conduct of any person, certainly he would be compensated by the wrongdoer. But if there is violation of any mere legal right, but there is no actual damage takes place, then what will be the consequence? That means if any suffers some injury because of the conduct of any person, but there is no actual damage, then what will be the consequence? That means whether that person will be remedied or not. That is the covered by the doctrine of Injuria sine damnum. That means injury without actual damage. This is the topic of discussion today. Injuria sine damnum etymologically means infringement or violation of the legal right without any damage. That means if any person suffers by the conduct of any person from any infringement of legal right or violation of the legal right, though there is no actual damage takes place, but still he is remedied by the law of torts. That means if any person by his conduct has violated or infringed the legal right of any person, but there is no actual damage takes place, but still the sufferer, that means who has suffered by that misconduct, will be compensated or remedied by the law of torts, that is the Injuria sine damnum or injury without actual damage. So, this doctrine has a similarity with another doctrine, that is ubi jus ibi remedium. That means whenever there is a right, there is a remedy. So, if any person has a right, that means he has some remedy. That means in case of violation or infringement of that right, he has some remedy, because without remedy the right has no meaning. So, the meaning of the right will be vexatious if it is not efficacious if there is lack of remedy. So, only remedy can substantiate the right, and it has another contrary opinion which I have already discussed in earlier episode, that is Damnum sine injuria. That means damage without any injury. We have already came to know that damage, if there takes place, but there is no violation of the legal right, then it is not actionable. But it is the contrary view in case of Injuria sine damnum. That means if there is the contrary position, that means there is the violation of the legal right, but there is no actual damage, then relief can be obtained. So, Injuria sine damnum etymologically means that injury without damage, and contrary of the damnum sine injuria, that is damage without injury, and it has a similarity with another doctrine ubi jus semi remedium, that is where there is the legal right, there is some remedy. So, damnum sine injuria and injuria sine damnum, it is the contrary view, it is opposite, and similarity with the ubi jus ibi remedium. So, now I am discussing elaborately about this doctrine with citations or case references. In order to understand the concept of Injuria sine damnum, we have to consider two classification of rights. There are basically two rights, one is absolute rights and another is private rights. Absolute rights are by nature actionable per se. That means without strict proof of the damage, it is actionable. That means if there is violation of the absolute right or infringement of the absolute right, it is actionable per se. That means by itself it is actionable, whereas private rights are not actionable per se. That means in case of violation of the private rights, actual damage is necessary to be proved. Unless any person proves the actual damage, then there is no remedy for violation of the private rights. So, some example can be given in case of violation of the absolute right, or that means the legal right, like trespass or assault or battery or false imprisonment. These are the example of violation of the absolute right which are actionable per se. That means if there is any trespass or there is any assault or battery or false imprisonment takes place, it is actionable per se. That means no actual proof of damage is necessary to be proved by the sufferer. Whereas in case of private rights, like if it is violated, like negligence or nuisance. So, in case of negligence or nuisance, actual damage is necessary to be proved. Otherwise, there is no remedy in case of law of torts. So, in case of negligence or nuisance, the sufferer must prove the actual damage against the wrongdoer, then only he is entitled to get some relief, otherwise not. But in case of violation of the absolute right, there is no necessity to prove any actual damage, because it is actionable per se. By itself it is punishable, means compensation can be awarded. Salmon stated once that there are some wrongs which are though harmful but are not wrongful, like Damnum, Sine, Injuria I have already discussed, and it is the contrary opinion. So, it can be said in the light of Salmon that there are some acts which are wrongful but not harmful, but they are remedied, because by virtue of Injuria, Sine, Damnum. That means though they are actually wrongful, means there is infringement of the or violation of the legal right, but they are not harmful. That means there is no actual damage takes place, but still by virtue of this doctrine Injuria, Sine, Damnum, that can be relieved or it can be remedied. That means compensation can be awarded by the court of law. So, rights, basically there are absolute rights and private rights, as I have stated. Now, it is actionable per se, by itself it is punishable, whereas in case of private rights it is actionable only upon proof of actual damage. So, categories like example like trespass or assault, battery, false imprisonment, whereas examples of private rights are like violation of some rights like negligence or nuisance. So, it can be said that in case of trespass, assault, battery, false imprisonment, no actual damage is necessary to be proved. It is sufficient if the incident is proved that there is the trespass or there is the assault or battery, whereas in case of private right violation, like in case of negligence or in case of nuisance, the actual damage is to be proved. So, this is the basic difference. So, in case of Injuria, Sine, Damnum, whereon on, in this case it is related with this aspect, that means trespass, assault, battery or false imprisonment, when if any of this incident happens, then it is actionable per se. That means without strict proof of any damage. That means it is actionable even if there is absence of any actual damage, because it is actionable per se, by itself it is punishable. Now, I am discussing this concept with some judgments. Now, I would like to discuss about the first landmark judgment regarding Injuria, Sine, Damnum doctrine, that is SV versus White, decided in the year 1703. What happened in this case, that plaintiff was a genuine voter during the parliamentary election and he tendered the vote, but without any basis, without any reasonable ground, his tendered vote was not registered by the returning officer. So, it was decided by the court that it is unfair to not register the vote tendered by the plaintiff, because returning officer without any basis, without any reason refused to register the same, and it was observed by court by Chief Justice Holt in this case that if any person has a right, he must have a way to vindicate their same. If he cannot exercise such right because of the obstruction or any hindrance put by someone else, then he must have some remedy, because want of right and want of remedy are reciprocal. So, in this case compensation was awarded. This is a very prominent case for Injuria Sine Damnum. Now, I am discussing another landmark judgment, that is Bhim Singh versus State of Jammu and Kashmir, decided in the year 1986 and reported in AIR, and it is decided by judges Chayanappa Reddy and V. Khalid. What happened in this case? It is the gross violation of Article 21 of the Constitution of India, because we know that in pursuance of Article 21, every citizen has a right of life and liberty. It is stated that no person can be deprived from enjoyment of his life and liberty except the procedure established by law. But what happened in this case, that Bhim Singh, he was a member of the Legislative Assembly of Jammu and Kashmir, but while he was going to attend one assembly session, he was detained by the police and he was not produced before the court of law by the police, which is grossly violation of constitutional right as well as non-compliance of the Code of Criminal Procedure. So, he was not produced before the court of law in pursuance of the Code of Criminal Procedure, and that is why as a result he could not attend the assembly session. It was decided by court in this case that an exemplary damages was awarded of rupees 50,000, and moreover this type of detention also wrong in pursuance of law of torts, because it is a kind of false imprisonment, as well as it is an offence by virtue of Indian Penal Code, because it is coming directly under the purview of wrongful restraint and wrongful confinement, because we know wrongful restraint as it is defined in section 339 and confinement 340, and which are punishable in accordance with section 341 and 342 of Indian Penal Code. So, the compensation was awarded by the court in the instant case. So, I have decided these two judgments. Now, first was the SB versus White, as I have stated, and the similar, that is the Indian perspective, Bhim Singh versus State of Jammu and Kashmir. In both cases the compensation was awarded and directly related with the Injuria Sine Damnum doctrine. Now, I would like to discuss few other cases. In one leading case, Antique versus Carrington, it was decided that every invasion, whatever may be it so minute, into the premises of other person is tantamounting to trespass. So, any invasion, be it ever so minute, into the premises of some other person amounting to trespass. That means, mere setting of foot without seeking the permission of the other into his premises tantamounts to trespass. So, trespass is such a wrong in the law of torts, where the mens rea or motive is immaterial. There may be no wrongful intention, but still it may amount to trespass if without seeking the permission of the owner of the land he has entered, some stranger has entered into his premises. It may be that he has not damaged anything, that means even he has not plucked a single flower, but still it may amount to trespass. That means the guilty intention is not material, or actual damage is also not necessary in order to constitute the wrong of trespass. Mere entry into one's premises without seeking the permission amounting to trespass, provided he has entered there voluntarily. If it is involuntary in nature, that means he was forced to enter, then certainly it is not coming under the purview of the trespass. Only one thing will be considered by the court of law, that whether it was voluntary or not. So, if voluntarily a person has entered into someone's property without seeking the permission, that certainly amounting to trespass, and there is no necessity for removal of any enclosure or something. He has entered and he has not caused any damage, but if the entry is without seeking the permission of the landlord, then it is certainly amounting to trespass. So, as I have stated that in Antique versus Carrington 1765 it was decided by the court. So, it appears from the discussion that in case of trespass the doctrine of injuria sine damnum can be related, because in trespass there is no actual damage, but still it is actionable. Similarly, in case of assault, we know that Winfield stated that assault is such a wrong on the part of the defendant which creates some apprehension in the mind of the plaintiff of some instant fear of battery. That means, there is apprehension caused by the conduct of the defendant about some battery. That means, there is the reasonable apprehension that the plaintiff thinks that there is the chance of some battery that can be caused by the conduct of the defendant. As for example, it can be cited that if any person threatens another person with a pistol, though the pistol is not loaded, but the person, means the plaintiff, can apprehend that he may be injured. So, this is the assault. And similarly, if any person brandishing the sword aiming a particular person, where there is the reasonable apprehension that he may be stricken by with such sword, and it is also the assault. Maybe there is no actual damage or injury takes place, but still this apprehension will cause the assault. So, in these cases the remedy is there, compensation can be awarded, because these are connected with injuria sine damnum. That means, there is violation of the legal right, though there is no actual damage takes place. So, it can be concluded with the observation that in case of injuria sine damnum, court is emphasizing upon the infringement of the legal right than the actual damage. So, in case of damnum sine injuria, we got the contrary view, but in case of injuria sine damnum, the court is emphasizing that even though there is no actual damage takes place, but still there is the infringement of the legal right, so that is actionable.